Well, thank you very much for that kind introduction, and thank you very much to the Kenyan Institute and the British Council for inviting me. I have to say that I am fighting a bit of a cold, as one does when one gets off a plane, so I apologize for that. Although I teach in a law school, and I will touch on many issues that are to do with international law and the use of international human rights and humanitarian law. Yeah, better? More? Okay. Is this better? Okay. Although I teach at a law school and I will be talking in some detail about the use of different kinds of accountability mechanisms, I am also a social scientist, so a lot of what I will be speaking to really is comparative experiences in attempting to negotiate peace agreements alongside demands for accountability. So it really is about very much the tension as the talk sets up, but also about the diversity of experiences, good, bad, and indifferent, that we've actually seen around the world. I want to just put this in context for the region, but emphasize that I am not a researcher who works in the Middle East or North Africa. My research has largely been in Sub-Saharan Africa, in South Asia, and in Latin America. But I do think that there is a great deal to be gleaned from experiences elsewhere that help us to think through what some of the challenges are in seeking to promote accountability alongside seeking to promote peace, and be as clear-eyed as possible about where the challenges are too severe to accomplish both and where some compromises might turn out to be quite interesting. So I put this in the context of the so-called Arab Spring, which I immediately would problematize, as I suspect many of you would, as not being purely Arab nor actually having started in a spring. But I don't think that that's important. There just seems to be a discourse that insists on using this language. But I think the reason that it's an interesting jumping off point for us today is because there has been a sort of a flood of people wanting to talk about the possibility of accountability and transitional justice in the Middle East and North Africa in the wake of these various forms of social revolution. And I think it's therefore important to sort of think about, well, what can we learn from elsewhere? So I've just pointed out, and this is just by way of a caveat, and it could have been a quote from anywhere. It happens to be a quote from a Chatham House report, basically acknowledging that all of the situations that we might attribute to the Arab Spring are different and distinct, but one of the commonalities are the fact that what we're looking at, both during the context of the social revolutions, but also prior to them, are situations of quite grave human rights violations, right? Okay. Are situations that have involved very severe human rights violations, which means, as elsewhere in the world, as one would expect, one is seeing demands for accountability alongside arguments about the importance of stability rather than promoting accountability. So again, while noting that every situation is different, I wanted to ask, what are some of the lessons we can learn from elsewhere? Or if not lessons, perhaps warnings. So I want to start, first of all, with, and it's somewhat well-worn at this point, but I think worth reminding ourselves what the two poles of this debate are, the so-called justice versus peace debate. And it's often couched in this way, as one of really values versus pragmatism, right? There are a set of idealists who believe in human rights and the rule of law, and those are the principles that they want to promote above and beyond really all other outcomes, and indeed invoking statements or invoking quotes like "let justice be done, lest even if the heavens fall." And this is couched as in stark opposition to pragmatism, to realpolitik, and focusing on the importance of ending conflict or ensuring stability. What's interesting about this is that actually neither of these camps make purely one or the other type of argument. Right. So on the side of values, the virtues and human rights, those arguing for accountability in the wake of conflict do very much emphasize normative values. Right. They emphasize the importance of the rule of law. They emphasize the importance of particularly protecting human rights and particularly protecting the vulnerable. But they also very much make a pragmatic argument, right? They also argue that in the absence of justice, you can never have a really stable and durable peace, right? So they're actually making both kinds of arguments. And similarly, those who argue that what we should actually be doing is choosing peace rather than accountability, because accountability is too disruptive. They make a pragmatic argument, right, which is about stability. But they also make a normative argument, which is actually that focusing on peace will help prevent future human rights violations. Don't we want to stop the conflict now so that more people aren't tortured or disappeared, right? And so what we see is that both camps actually make both normative or value-focused arguments and pragmatic ones, right? But I think the critical question, and I've alluded to this already, is the challenge that we face because, in fact, these are frequently inconsistent goals or foci. How do you actually respond to the demands for accountability coming from citizens, coming from victims, and increasingly coming from a very vocal set of international justice advocates, largely coming from the North and so on, and at the same time seek to limit the harm that may come from very strong resistance coming from the old guard, those who have something to lose by talking seriously about the past. So how do you actually begin to weigh this balance, particularly in situations where the old guard have significant capacity to be disruptive, right? They still retain significant economic power, military power, and so on. So this is often set up as a very stark opposition that suggests that you really must make a choice between one or the other. And so I wanted to talk us through actually the wide range of experiences that we've actually seen globally over the last few decades, with countries going through different kinds of transitions, coming out of authoritarianism, coming out of violent conflict and internal civil wars, how they have actually dealt with these tensions or with these two demands, right? The demand for stability or peace and the demand for accountability. So to give a couple of examples that would suggest that accountability is, at least in the first instance, quite destabilizing, may prevent peace from being reached. I'll start with Argentina, where in 1983, there were actually prosecutions, and 5 of the 9 members of the military junta that had ruled during the so-called Dirty War, in which tens of thousands of people were killed or disappeared. That 5 of the 9 of them were actually convicted, 5 of the 9 generals. However, there were then 5 major coup attempts by the military, which generated a great deal of fear about the reasonableness or suitability of continuing to pursue accountability. So what happened was, in fact, pardons were put into place for these five generals, and all attempts at accountability were halted. I'll come back to Argentina in a moment, because it's actually quite interesting, because they have been revisiting this situation on a number of occasions. We could think about also the arrest warrant of the International Criminal Court for Sudanese President Omar al-Bashir. And I think we'll all be familiar with the deep concerns that the issuance of that arrest warrant may have made his regime more intransigent, may have actually worsened the conflict in Darfur. I don't know if there's any way we can actually know if that's true or not. But what we do know was that al-Bashir and his regime said very strongly, by issuing this arrest warrant, you're calling us a failed state. If we look like a failed state, well, I guess we can't control the situation in Darfur. And in fact, the humanitarian situation did get considerably worse for a period of time after the arrest warrant. Whether that was the cause or not, I don't know that we could say. But I think these are important examples of where it is quite risky to pursue accountability when you're dealing with powerful elites. The alternative extreme is a complete absence of accountability and, indeed, state promotion of amnesia. And I've given us 2 examples here. We could think of probably a number of others. Spain, after the Franco era, really had a policy of publicly enforced amnesia. It was not possible and remains almost impossible to talk about the legacy of the Franco era in a political or legal domain. People do talk about it individually, within families, among friends. But the insistence on amnesia is actually so strong that Baltasar Garzón, who is an investigating judge in Spain, who you may be familiar with as the individual who initiated the proceedings against Augusto Pinochet Ugarte of Chile, when he sought to actually use his powers to reopen Franco-era violations, he himself faced prosecution. Right, so this should tell us how strong the resistance is even now to taking up accountability questions in Spain. So does that mean amnesia worked, or does that tell us that amnesia is still being imposed because there are elements that fear talking about the past? There are still individuals alive who are responsible for abuses during that era. In Mozambique, it's a very different situation, but there was similarly state-imposed amnesia, right? A generalized agreement at the top, after the end of that civil war, to insist that we don't talk about the past. And one of the interesting things is that continues to be the case. It continues to be impossible to talk about prosecutions, to have a truth commission in Mozambique. However, what you see are spontaneous uses of what is essentially a traditional justice mechanism, not imposed from the top in the way that it was in Rwanda, but actually coming from the bottom, of people confessing or demanding that individual perpetrators come to proceedings and confess. Is a complicated word. It's a spirit-based process that involves what to outsiders like myself sound like hallucinations, but which have very specific cultural meaning. And as I say, are being taken up and chosen as a way of dealing with the fact that from the top down, amnesia is imposed, but people remember. So I think, again, what we see is the imposition of amnesia is sometimes a popular tool, but not terribly effective, because people don't actually forget. You know? I'm going on to think about, well, what are the effects of accountability processes? It's also possible that in some cases there's no evident effect one way or the other on stability. So I've given an example here that a lot of people don't know about because they're not talked about much outside of Sri Lanka. But Sri Lanka in the 1990s, after the election of President Kumaratunga in 1994, had a series of commissions of inquiry into disappearances, into political assassinations. Notably, of course, one was of her husband, right? So we can ask, there we had vested interest in finding the truth. So it's distinct from the other way around. But there were also prosecutions of several major incidents of abuses by security forces, including a massacre of school children in Ambilapitia. Right? So there we have a really interesting situation in the sense that this was a country in the middle of a long-running civil war. Right? This is a country in which you would have expected claims of security to be paramount and win every time. Why on earth would we risk a reaction by the military or the police to any prosecutions, any response to the abuses that they had committed? And as it turns out, there was no destabilizing effect at all. That may be very peculiar to a whole series of things about the situation in Sri Lanka, but it's well worth noting that in this case, justice didn't cause further instability. It also in no way contributed to the end of the war, and I think for those of us who watched how the war ended, what we do know is we've now had a termination of conflict and an absolute impossibility of talking about justice. So I think we've sort of come full circle there. So those are some of the ways in which there may be an effect from justice mechanisms. I'm carrying on to some other mixed records. It's possible that having accountability mechanisms could be both peace-preventing and peace-promoting. This argument has been made both ways, for example, with regard to northern Uganda. Right? The argument has been made that it was the arrest warrants, in this case particularly for Joseph Kony, the leader of the Lord's Resistance Army, and his various lieutenants, that is what caused the failure of the Juba peace talks. That is why there was no successful peace agreement. On the other hand, people argue the other way and say, look, the arrest warrant caused he and his comrades to flee into, quote-unquote, the bush. And indeed, they have largely left northern Uganda. Right, now there's a different problem. They've actually brought conflict to the Democratic Republic of Congo and a number of other neighboring countries. So if there was a peace-promoting effect, it may unfortunately have only been for northern Uganda. But there is no question that people have returned from IDP camps, people are returning home, and so you see a fundamental change in the situation there. It's a very strange mixed response as a result of those arrest warrants, right? You might also argue, looking at Colombia, that there were elements that were peace-preventing and elements that were peace-promoting in talking about accountability. In the Colombian process, you have a very strange fusion of an accountability process that involves some trials for some members of the paramilitaries, the demobilization of members of the paramilitaries, and reparations processes, all bound up together. This was accidental. It was not by design. I could explain more in Q&A how we ended up in this very strange situation. And they've largely been successfully demobilized. The process has also resulted in about 15,000 members of the FARC self-demobilizing to take advantage of the same process. Right? So we do have a significant decline in armed violence coming from these groups as such. However, many of the members of the paramilitaries have simply reformed into different kinds of criminal gangs. Right, so we don't necessarily have more peace in Colombia. What we have is a clear decline in the paramilitaries that we saw before, and a true significant demobilization of members of the FARC, of one of the major rebel groups. So again, I think we see peace promoting and peace preventing in Colombia. Many people would argue that accountability processes can be peace promoting by pointing to the Special Court for Sierra Leone and its ultimate removal of Charles Taylor from the political game in West Africa. But one could argue this both ways. For those of us who recall when the peace negotiation was completed in 2003 in Accra, Ghana, Taylor was already under an arrest warrant from the Special Court for Sierra Leone, and many feared that it would actually cause a breakdown of the Liberian peace process. It did not, but only because Nigeria offered him exile, and it was an exile that he thought would be permanent. And when he went into exile in Nigeria, he not only said, "God willing, I will be back," which most people in West Africa did not take to be a good promise, but he proceeded from his base in Nigeria to try and manipulate levers of power still in Liberia and to a degree in Sierra Leone. So did the peace agreement remove him? Did the promise of exile remove him? Or was this partly the effect of the Special Court for Sierra Leone? Those who want to argue that accountability can help promote peace will obviously say it was because of this indictment he had something to fear. But others might argue, well, it was actually that he was being forced to the peace table, right, by an international effort to compel the end to the conflict in Liberia, and that the court itself had nothing to do with peace and stabilization, certainly for Liberia, since the trials were actually, were and continue to be, about crimes committed in Sierra Leone, of course, only. So you can argue it again both ways. There's also the sort of strange journeys that we've seen with a number of Latin American countries, right, with the quite delayed processes of justice in different ways. So to come back briefly to Argentina, what we've seen is a regular return to discussions about accountability, pushed very, very significantly by what were the mothers of the disappeared, and also now by a generation of children who were stolen by the military junta. Right? They were stolen from their parents, relocated and given to military families. They're now seeking to out the truth. Right? So you're having different generations now pushing for accountability. And indeed, a number of trials of former junta members were taken to Spain through the exercise of universal jurisdiction, very much with the encouragement of then President Kirchner of Argentina, who was of the view, and this was now about 7 years ago, who was of the view that Argentina wasn't able to deal with them yet. In more recent years, in fact, that process has been reversed, and at their request, many of those cases are now being heard in Argentina. And rather more strangely, to come back to the amnesia in Spain that I talked about, there are efforts to use universal jurisdiction in Argentina to try Franco-era crimes from Spain. Which, if successful, would be the first situation in which we've seen the exercise of universal jurisdiction in a developing country, and effectively in a country outside of Europe, with one exception that I'm coming to. Similarly with Chile, again, I've mentioned Pinochet. Obviously, Pinochet was never tried in Spain, but in fact, part of the journey that brought him to house arrest in Chile was by way of the attempt by Spain to exercise universal jurisdiction so that he would actually face accountability somewhere. Now, as we may well know, although he was arrested in the UK and the UK was prepared to extradite him to Spain, they ultimately did not for humanitarian grounds, on the grounds that he was both physically and at this point mentally ill. So he was returned to Chile, but what is interesting is that many of the pardons and self-amnesties that he had made sure were put in place when he left power in 1991 were stripped of him. Right, so he remained under house arrest until he died, and repeatedly faced the threat of being prosecuted in Chile. And again, as we know, it was not disruptive to stability in Chile. He rather notably and disturbingly managed to actually die on International Human Rights Day, and an irony that I think wasn't lost on many of us. So again, you see really pointing in two different directions, that in early days it's almost impossible to have accountability, or at least in those two countries, it turns out to have been too destabilizing or impossible. But that in fact what you see is the repeated demands for accountability that eventually do get met in some form, right? So that in fact what you see is justice delayed and in this case relocated via Spain. I wanted to talk about, having talked about the mixed impact of accountability, I wanted to point out two things. Peace processes and peace agreements are not all the same, nor are accountability processes. So when we think about how they interface with each other, we have to think about the complexity of both. We have to think about the different modes of peace agreement. We have to think about the different modes of accountability, because they don't all intersect in the same way. And many of the modes of accountability, as we'll see, don't necessarily involve criminal prosecutions. So I wanted to point out, first of all, peace agreements with very explicit amnesties. And I think the classic example of this now, in part because it was so embarrassing for the United Nations, was the Leone Peace Accord of 1999 for Sierra Leone, which included a blanket amnesty. The term was absolute and free pardon for absolutely everyone in the conflict. That was done with the expectation that this would end the conflict. And in fact, alongside that, Fode Sanko, who was the leader of the RUF rebel group, was given a vice presidency and effectively the Ministry of Mines. He nonetheless went back to fighting within 6 months. So that suggests perhaps that these incentives were not sufficient to cause peace or to generate peace. Or, as I would argue, given that the RUF effectively controlled the territory where most of the diamond mines were in Sierra Leone, that he wasn't being given anything he didn't already have. Right, so there just wasn't much interest in the results of this peace agreement. Now, the scandal surrounding this has resulted in quite clear marching orders now for UN mediators. They are not allowed, if they're United Nations mediators, they are not allowed to include blanket amnesties in peace agreements. They're not allowed to support the mediation of those agreements. So there are peace agreements that still include amnesties, but the UN cannot be part of them. Similarly, and this has become the much larger trend, you have peace agreements which are simply silent on questions of accountability, right? They simply resolve the problem by not talking about it. But most importantly, make accountability verging on impossible because they ensure the preservation of the powerful through power-sharing arrangements, right? So through ensuring that basically all sides to a conflict get a piece of governance, they get a piece of control of the security forces of the new state. Basically, they're embedded in power in a way that allows them to ensure that accountability isn't possible. So you don't have to have an amnesty, right? They can enforce that themselves on a relatively long-term basis. And I've given a couple of examples here. The Sudan Comprehensive Peace Agreement is an example that was of an agreement that was completely silent. The Darfur Peace Agreement, which was heavily modeled on the overall North-South Sudan Peace Agreement. The political settlements in Kenya and Zimbabwe, all of these involved power sharing that basically allow those who are responsible to protect themselves. And in fact, in Kenya, the power-sharing government, which likes to call itself the government of national unity, is jokingly called by Kenyans the government of national impunity, right? Because they know exactly what's going on. It will be extremely interesting to see what happens, given that now 2 of the contesters for the presidency in Kenya are actually under indictment by the International Criminal Court. They're not those currently at the top echelons of power, but they're the ones who are vying for it. So it'll be very interesting to see what happens as the elections move forward in Kenya, which Finally, you can have peace agreements with conditions for future participation in power, or provisions for accountability processes that are more limited, right, that don't relate to prosecutions, but ensure, for example, that if in fact you were a human rights abuser as a member of the military or the police, you were removed from that role. Right, so that is another mode of accountability that is in some cases built into a peace agreement, as was the case, for example, in El Salvador, which led, actually, the negotiating process led with a focus on human rights monitoring. That's where it started. And then eventually expanded to questions about military demobilization and other issues. And so it had very clear provisions for vetting of the security forces. It's interesting to see. And the human rights training that all of the police forces are now compelled to go through is actually quite thorough. Now, how much of it they take on is always going to be another question. But I did want to emphasize that those are ways in which you have very different types of peace agreements that do or don't speak to the question of accountability more or less directly. And similarly, I wanted to emphasize that there are different modes of accountability, and I wanted to start with non-criminal modes of accountability and then move on to criminal ones, and say a few things about some of the pros and cons. Obviously, and I think we'll all be very familiar with the Truth Commission model, right? There are now, at last count, more than 35 truth commissions that have been created since the 1980s, with varying degrees of power, right? Some have had powers of subpoena, they could actually compel testimony. Some have had very little power, right? They really couldn't get anyone to come, much less say anything truthful, and they didn't really have anything to offer. And they've had very different types of report, right? Some have actually named who was responsible for particular violations. Some found that too dangerous. So, for example, the Chilean Truth Commission simply explained incidents. So they talked about violations in particular locations, which anyone who is familiar with the situation in Chile would immediately be able to attach to a particular commander. They would know who was responsible for that region, but they deliberately did not put names in the report. As we know, South Africa had an extremely robust Truth Commission in many senses, insofar as it obviously had the capacity, if it didn't grant amnesty to persons who refused to testify, to ensure that a criminal prosecution go forward. Now, of course, as we know, there have been very few prosecutions in South Africa. So whether, in fact, that procedure was as strong as originally imagined is an open question. We also see situations of conditional amnesties again in South Africa, right, where, yes, you get an amnesty, but only when you're confessing to specific political crimes, right? You do have to go through a process. We see a wide array of situations with vetting and illustration. Again, non-criminal accountability, but quite meaningful. So, for example, in a number of countries in Eastern Europe, following the end of communism, individuals were not only removed from, for example, security forces, but if associated with particular abuses, could be prevented either on a temporary basis, in some cases 10 years, in some cases permanently, from working in their chosen profession. So this affected school teachers and lawyers in particular in a number of countries, right? This is a very direct way of holding someone accountable, although there is no criminal process, right? You also obviously have memorial and apology, and I think the important thing that one has to ask in thinking about these as accountability mechanisms is, when are they real and when are they not? Right? When are they simply pro forma processes versus when are they situations in which there is a genuine apology by the powerful for violations that they either themselves feel responsible for directly because they politically caused them, or that is their way of apologizing on behalf of the state. And here I was thinking of two examples. One was the apology by President Kumartunga in Sri Lanka for the 1983 pogrom and mass killing of Tamil civilians, largely in the capital, that really set off the civil war. And the other is a range of memorials that exist around Argentina and many other countries, of course, often related to sites of detention where people were tortured and disappeared. And it really just depends on how they're used. Are they actually attempting to make something meaningful to the population, something meaningful to victims, or as I say, are they in some way pro forma? There are obviously a host of countries that have had reparations, which can be a mode of accountability. They are certainly a mode of responding to harms that victims have experienced. So, for example, in Chile, children of the disappeared were excused from compulsory military service, which can make a certain amount of sense if the state disappeared one or both of your parents. Acting in service of that state, even after reform, would have to be a pretty terrifying thing. So that was one direct way in which this was done in Chile. In Sierra Leone, there was a reparations process that took place in 2009 with quite significant take-up. And in the situation in Sierra Leone, because of the really grievous bodily harm that was inflicted on numerous civilians, a big component of this is medical, right? So some of it is a matter of handing over cash as a form of reparation, which comes with its own problems, but some of it is actually involved medical repair. Okay. There are also many different modes of criminal accountability that may interface with attempts at peacemaking processes. And I just wanted to run through a number of different types and different levels, because I think particularly these days, when we think about responding to mass atrocities, we think about the International Criminal Court. And we should think about the International Criminal Court, but it doesn't have jurisdiction in many places, right? Or rather, it has jurisdiction over 121 countries, but it doesn't have jurisdiction in a significant number of countries where the crimes we care about may have occurred. Yeah. So you can obviously also have local domestic prosecutions, and this has happened in a range of countries, sometimes presented as human rights trials, but much more frequently responding to human rights violations, but through trials of what would be considered ordinary crimes, right? So treating a disappearance as a murder, right? Similarly, we've seen situations in which the trials may be about something that turns out to be somewhat different. So, for example, the trials in Tunisia were actually ultimately about corruption charges, not about any human rights violations. Whereas in the Democratic Republic of Congo, in Eastern DRC, and only in Eastern DRC, a reconstructed court system has been taking on trials for serious international crimes as such, for war crimes, for crimes against humanity, and this is how they've been prosecuted. We also see a range of transnational domestic prosecutions, and I've talked about universal jurisdiction a bit already. We've seen, for example, attempts to prosecute a number of Israeli officials in Belgium, particularly for Operation Cast Lead in 2009. Successful prosecutions of former Argentine junta members in Spain, as I've mentioned, and perhaps rather infamously, the trial of Adolf Eichmann by Israel. And I say particularly infamously because, of course, it began with his kidnapping from Argentina. So we see a range of different types of uses of universal jurisdiction, and of course, finally, the cases related to Pinochet. The interesting question here is how do prosecutions that take place so far away from a country that's coming through a transition affect its transition, or do they actually have less of an effect precisely because they're happening at a distance? We also have, and these aren't criminal accountability, but I think they're worth mentioning because they've been an important mode of pursuing human rights accountability in a venue that otherwise wouldn't be available to many citizens of the world. These are non-criminal cases through the Alien Tort Claims Act in the United States, where individuals such as Radovan Karadzic, who as we know is now being tried at the International Criminal Tribunal for the former Yugoslavia, but also against corporations, including the oil corporation Unocal, for its alleged complicity with crimes committed by the regime in Burma, and indeed against Caterpillar for related to its sale of bulldozers destined for use in the West Bank. All right, so we do see that even though these are civil cases, they're an attempt to hold to account not just individuals but also corporations for engaging in actions largely because they're in pursuit of profit, that in which they choose to turn a blind eye to the abuses being committed by those with whom they're doing business. And in Q&A, I can come back to where those actually stand procedurally. And just to move on to some final modes of international criminal accountability, we've seen, of course, the ad hoc international criminal tribunals for the former Yugoslavia and Rwanda. We'll be familiar with the Nuremberg and Tokyo tribunals. These have all in different ways come under attack. The tribunals for Yugoslavia and Rwanda for being incredibly slow and costing a huge amount of money. And when I say huge, I should emphasize that each tribunal each year costs $100 million. I don't think that many people know that. They're extraordinarily expensive. It doesn't mean they're bad things. It does mean that we have to think about whether or not we're getting, as people like to say, value for money. There were obviously different criticisms to be made of both the Nuremberg and Tokyo tribunals, largely the question of victor's justice, right? But I think one of the biggest criticisms that we might want to think about for the tribunals for Rwanda and the former Yugoslavia is just how far they actually are from the affected populations, right? And the degree to which their proceedings, particularly for Rwanda, haven't been very accessible to the populations affected. And that's just because of the simple distance, and in the case of Rwanda, poverty, limited electricity, and limited levels of literacy. So people really aren't able to follow trials that are actually taking place in the Netherlands. Or in the case of Rwanda, many of them are taking place in Tanzania, which neighbors Rwanda, but is still sufficiently far that they can't go and observe them. And it's for this reason that we saw the creation of what are called hybrid tribunals or mixed tribunals, the attempt to create tribunals that actually operate on the territory of the affected country, but that have a mixture of domestic and international judges and domestic and international lawyers. This for a number of reasons. One, to make them accessible to the population. So in Sierra Leone, the running line, if you're a fan of the court, is to say, look, anyone can walk in. And that's certainly true. Once you surrender your weapon and whatever else you need to do, you can simply walk in off the street, or you could. Most of their proceedings are now done. And you can go and observe. And this was really an attempt to respond to concerns that if we're actually having prosecutions for an affected society, for victims, how can they be taking place so far away that they don't actually know they're happening at all, right, the affected populations? So similarly, we've seen the extraordinary chambers in the courts of Cambodia, which is a similarly mixed structure, and which notably allows victims to have their own representatives. Right, so in fact their own legal representatives, right? So in addition to having a prosecutor and a defense attorney, you have an attorney for a group of victims present in the courtroom, and they're allowed to ask questions. So this is it's relatively unique in international criminal justice, but in fact the International Criminal Court also has moved in that direction, not as far. We've also seen the War Crimes Chamber in Bosnia-Herzegovina, and I think more disputably the Special Tribunal for Lebanon, which really isn't about past atrocities or about a peace agreement. It's about the assassination of Rafiq Hariri and doesn't actually deal with any international human rights or humanitarian law crimes. Right? It deals with his assassination and the assassination of a few others. So there's a range of these types of mixed tribunals, and they seem to be perhaps flavor of the month. One of the things that it seems to get suggested when you have a conflict is that what you need is perhaps a truth commission and perhaps a hybrid tribunal. This was part of the strong recommendation following the post-election violence in Kenya. There's an immediate move to say what we need is something like the Special Court for Sierra Leone. Now, it was never created because the politicians who remain in power were afraid that it might actually work. And those who were actually in favor of human rights were afraid that, like most of Kenyan courts, it wouldn't work at all. And so they managed to repeatedly kill any bill for very different reasons, but to repeatedly kill any bill that would have resulted in a hybrid tribunal. And finally, of course, there's the International Criminal Court, which I think we're all familiar with, which has a number of strengths and a number of serious weaknesses, right? Its strength is its increasingly global reach, right? Its strength is that it does have, as I said, 121 state parties, now representing all regions of the world, although Africa is perhaps the most strongly represented numerically. In terms of the general coverage, Western Europe is obviously the most represented. But of course it has limitations. It cannot prosecute crimes that took place before July the 1st, 2002. What that means is that the court receives a huge number of communications from people about very serious crimes that fall outside its jurisdiction. So from villagers in Guatemala wanting to raise the question of massacres that took place in the 1960s. Massacres, in this case, of a Mayan indigenous population that may have constituted genocide. But the court can't hear those cases. It also still clearly has a problem with territorial jurisdiction. It doesn't cover the entire world. And as we know, there are significant powerful states, including China, Russia, and the United States, who are not state parties and who have, until recently, been strongly opposed to the court extending its jurisdiction to non-state parties. The two exceptions they've made have been in the case of two regimes, right? In the case of Sudan, in the case of Libya. And I think we might want to talk in Q&A about why that might have been. But this leads me to a sort of final concern that I have about the International Criminal Court, which is the fact that the United Nations Security Council can refer cases to it. Now, the reason that I raise this is because it effectively ties a court, a judicial institution, to very significant geopolitical pressures. And makes it appear, and perhaps makes it, politicized. It's obviously never possible, and I would not want to pretend to argue that judicial institutions are ever apolitical, but there are degrees of politicization. And the tie to the UN Security Council obviously puts the court at risk in terms of its reputation and how it's perceived. This is not helped by the fact that its entire caseload is currently, it continues to be in Africa, which raises other sets of perceptions. And so I wanted to come to a final number of points, and I apologize, I should have put this slide up, I've spoken to it without you seeing it. There continue to be concerns about selectivity, right? Not just the question of, is the court picking on Africa, but in fact, within particular situations, is the court picking the right defendants? So it would be difficult to argue in the Democratic Republic of Congo, particularly given that the government itself referred the situation to the court, that the court is necessarily picking on the Democratic Republic of Congo. However, its very first trial was of Thomas Lubanga, who was a relatively low-level warlord. And the court has not actually managed to pursue more significant political figures, in part because they would have great difficulty actually obtaining custody over them. So there are allegations of selectivity in terms of who gets tried within situations. The same concern has been raised in the context of Kenya, where effectively those who have been named for prosecution are really second-tier politicians, and many Kenyans believe very strongly that responsibility for post-election violence extends all the way up to the president and the prime minister. So they look at who has actually been selected for prosecution and say, well, yes, take them, but what about the president? What about the prime minister? Right? So these questions get raised a lot. I've referred to a number of these other things already, the number of state parties and the geopolitics. I think the question of selectivity, particularly where we are, can't be spoken about without talking about the attempted referral or the attempted lodging of a declaration by Palestine of acceptance of jurisdiction of the court. This was lodged in 2009, and it was only earlier in 2012 that the prosecutor determined that, in fact, he couldn't go forward with the case. That's the headline story. What I think is interesting, and I could say more about this in Q&A, is that it took him 3 years to reach this determination, which I believe is indicative of the deep interest that he has had in the situation. And that, in fact, what he appears to have decided is hard to argue with from a legal point of view. That is to say, as the prosecutor of an international criminal court, he is not vested with the authority to decide who is considered a state and who is not. That is, as he pointed out, a determination for the United Nations Secretary General, for the United Nations General Assembly, or, interestingly, as he suggested, perhaps that could be a determination made by the Assembly of States Parties of the Rome Statute, the statute establishing the International Criminal Court. A really interesting suggestion, because that would actually necessarily exclude some of the states who would object, such as the United States, to treating Palestine as a state. Right? It effectively puts the decision potentially in the hands of a significant number of states who might be more willing to support this kind of determination. That, to me, we'll have to wait and see. So I think we do end up in a very frustrating situation, because with Palestine, and as with many other locations where you don't have a state party, it's hard to see how you get a case to the ICC unless you have a Security Council referral. So as someone who works on Sri Lanka, and I know the prosecutor was extremely interested in how that conflict ended as well, I'm frustrated, right? There were clearly extremely egregious war crimes that took place in the last few months of that conflict. Sri Lanka is not a state party. There were no crimes very clearly committed against any citizens of a state party during that conflict. So there's no accountability. The question is, what can we do about it? And I'm not sure that I have an answer, because I do think this brings us back to the questions of geopolitics that are beyond our control. What I would say is that I think we have seen a progressive development of mechanisms of justice, and really actually an explosion of international justice processes, but we still see huge gaps. What's interesting is we've also seen a rapid increase in peace negotiations and peace agreements. So these things are going along simultaneously adjacent to each other, even though nothing seems to be systematic, right? So it raises, I think, important questions that are very difficult to answer, such as, is it better to have some justice than none at all, even though we are then going to see transparently unfair situations where certain conflicts will simply not ever see an accountability process, or will only see it after 20, 30 years. But is it better to have some justice than none? I think another question, and this is a question that is very salient here, how do choices about accountability and about the structure of peace agreements change when you've got an asymmetric conflict, or where you have a situation of absolute military defeat? So I'm thinking in the context of absolute military defeat, a situation like that in Rwanda, right, where you have an absolute victory by the RPF and subsequent control of a state, in fact, in quite authoritarian ways, and decisions about whose accountability counts. Those who are accused of being responsible for the genocide may be prosecuted or go through a traditional justice process. Those who are accused of committing war crimes as members of the RPF cannot be prosecuted. And in fact, when the prosecutor of the International Criminal Tribunal for Rwanda attempted to indict members of the RPF for these alleged crimes, the Rwandan government had her removed. I could explain more about at what point this was and how this was possible. But we do clearly see situations in which if you win the war, or you remain in power through other modes, you control the story about accountability, right? You control who committed a crime and who didn't, who was really a victim and who wasn't. One of the questions that comes up, and I always hate to say this because it always sounds like I'm advocating straightforwardly against justice, but what about getting to peace first and letting accountability processes follow later? I think we've seen this, as I've mentioned, in a number of Latin American countries, as I've said, Argentina, and in a different way, Chile. In some ways, that may be one solution, and it has been for some states a solution to the tension between peace and justice, but it comes at a very serious cost, right? Pursuing these cases sometimes decades later, means that many victims may never actually see justice happen. It means that many perpetrators will live out their lives with their stolen loot, wherever they choose to live out their lives, and never face justice. And it means we have what can sometimes really look like a farce, which is the 80-year-old former dictator being rolled in on a bed. Right? We saw this in a sense with Hosni Mubarak. We've seen this again with the extraordinary chambers in Cambodia, where, in fact, if you actually look at the records relating to those who are being tried, some of them were born in the 1920s. They are very old. And so you get this sense that, well, yes, we are getting justice, we are getting delayed justice, and perhaps that's better than none. But it makes for a very strange picture. So I think what I wanted to close on was I've probably successfully given you more quandaries than answers, and I don't think I was pretending to solve exactly how one grapples with accountability and peacemaking at the same time, but rather to lay out some of the challenges and to have us think a little bit productively about, look, there are actually a lot of options. There are a lot of different ways to do a peace agreement. There are a lot of different ways to pursue accountability. Any choice has to be a choice specific to and appropriate to the specific context. Many choices appear transparently unfair and frustrating. But I suppose it's more important to continue to try and think about how you can get accountability and peace to work together than to simply say, well, it's a dilemma, you get one or the other, but you can't have both. So I think I'll stop there. Thank you.
Thank you.